Not every hill is worth dying on. Welcome to the Consultation. My name is Josh Floyd.
My name is Christina Jimenez.
We are both board-certified family law attorneys here at Jimenez Floyd Family Law Firm. And today we are going to discuss hills. Hills and dying.
And when to fight and when to settle. So here's what I'll say. What I will do is I will explain to people that this is probably the most difficult thing that you're ever going to have to deal with. And it's not just divorce cases, right? It's custody cases, modifications, enforcements, all of the things, right? Being in litigation is probably going to be one of the most difficult things you ever have to deal with in your life. And especially if it's contentious, right? And so I tell people it's going to try you emotionally, financially, spiritually, all of the ways that you could ever be pushed to your limits. This is probably going to be the process where you find what your limitation is. And so knowing when to fight and when to settle and having counsel that you trust that's going to guide you as to, listen, you're fighting over something you don't need to fight over. That's going to be the best thing that you can ever do in this process, is find an attorney that isn't going to take advantage of you, isn't going to be as emotionally charged as you, somebody who's going to be able to say, like, listen, let's pump the brakes and maybe let's decide that we're not going to fight this battle because it's not worth it.
Yeah, so that's the one thing about doing family law, right? Is I think it's the only area of law where every aspect of it is emotionally charged, right? We're dealing with kids, we're dealing with broken divorces and relationships. Even sometimes with kids, we're dealing with broken relationships, right? A lot of the other types of law, contractual and criminal stuff, we're dealing with, money and stuff like that. But every aspect of family law is emotionally charged, right? And emotionally draining. So that's the big thing, is how do you get past that? And can your attorney, get you away from your emotion long enough to think logically, so that that not every hill is worth dying on.
So, the way that I will always evaluate a case is, and I tell our clients this, like, I care about what you want because obviously I'm your advocate and I need to know what your desires are. Obviously, I care about what the other side wants as well. Because I need to know how to, potentially argue against that if my client doesn't want the same thing. But really, who I am mostly concerned about throughout the entire process is the judge, right? We have been very diligent about choosing certain jurisdictions that we practice in very often, so that way we know, like, this is how this judge feels on this particular issue, because it helps us to guide our clients, right? And so when I'm looking at a fact pattern, or I'm talking to a client, I assess it as a fact pattern, right? I will think, what is the judge going to do in this particular situation? And if I can settle this case pretty damn close to what I think the judge is going to do, or even get my client something better than what I think the judge will do, then I have done a really exceptional job for that particular client.
Yeah, because continuing litigation is expensive financially and emotionally, right? And so if you can get to that point without having to go through and put the family through all of those hurdles and expenses, that's the best way to go for it.
Well, and I'll tell you, like, a lot of times those are very difficult conversations to have, right? Because a client is very very emotional, and they have their own way of thinking, like, this is what should happen, this is why it should happen, this is the evidence that I think that I need to present, and surely if the judge hears this piece of evidence, then there's no way that they can rule in the favor of the other side. And unfortunately, that's just not always the case. And I'd say, 9 times out of 10, I've probably litigated that particular issue in the presence of this particular judge. And I know, listen, they're just not going to care about that, right? Like, I understand it's a huge thing to you. It's just not going to really land in this particular court.
Yeah, those are hard conversations to have because they don't understand. Like, they legitimately think that if A, then B, right? But having experienced all of that and gone through it, like I said, litigating that particular issue in front of the judge and trying to explain to them why the judge in this particular jurisdiction handles this particular situation this way, sometimes it's a real toll on us because we don't really know exactly why they are doing it this way. We just know that's the way they do it. Sometimes it's not logical. It doesn't make sense, right? Most of the time it follows what the law says, right? But it's not logical. So,
Right.
especially if you're not doing this all the time, like it's hard for them to understand why it is that way.
Right. So, one of the things that is very helpful in the context of these types of cases is 9 times out of 10, we will have a temporary hearing and then we'll have a final hearing, right? And so when I have a client who is, hypothetically speaking, just saying there's no way that this dad should have standard visitation of my 5-year-old. But there's nothing really wrong with dad, right? Like there's no criminal history, there's no alcohol history, drug history, there's no, abuse, there's nothing. But mom has this position of I've always been mom. The kid is always with me. Dad's never been alone with a child. The child just needs to be with me. Period. The baby can't stay overnight, right? He can have him during the day, just not overnight. Um, I would say 9 times out of 10, dad is going to get standard visitation, right? It's going to happen. But sometimes, these clients just have to have their day in court. And so we go in, we present all the evidence that they want us to present, and then they get to hear from the judge, like, okay, now dad gets standard visitation, which is helpful for settlement because it reframes their entire mindset on that particular issue.
And I think it builds trust in us when they do that. They're like, our attorney is not BSing us, right? They've been here, they've done that. They showed me in court, right? We presented everything we could, and this is what the judge ruled. Like, you had your day in court, you had your shot. It came out like we anticipated it would, right? And so it reframes their mindset,
Mm-hmm.
reframes their mindset moving forward, knowing whether, what their issue is worth dying.
Right. So, when should you fight, right? And those are, I think in most scenarios, like when you guys think that you should fight, I'd say, I don't know, 70% of the time we're like, yes, absolutely, we should fight, right? I'd say the other 30% is we have just a very emotionally charged client that doesn't understand the process, that doesn't want to listen and kind of have the realization of their particular situation. And in those particular cases, sometimes we still fight and they get to see it in court. But obviously, if there's safety issues as it pertains to children, right? So, any drug history, family violence, abuse, neglect, what else? Alcohol.
Yeah, but I think that the thing is, and the kind of what the distinguishing factor is, what we believe to be a safety issue,
Mm-hmm.
and sometimes what our clients believe to be a safety issue are two different things, right? Like you were talking about with the mom, not wanting overnight visits until the child's old enough to call me and tell me what's going on, right? That's not a safety issue to the court. But if there are these issues, like you said, drugs and family violence and what a criminal activity, etc., absolutely, we're 100% on board. That's when we should be fighting,
Right.
right?
So, and I'll tell people all the time that you have to be very careful when we're looking at those types of issues when it comes to custody, because it's not necessarily what it's what you can prove, right? And those are beyond frustrating when we are attempting to advocate for you in a courtroom. I have it happen, very consistently. Dad has an alcohol problem. He drinks all of the time. And I'm scared to death that he's going to drink and drive with my children because he used to do it all the time with me. Okay, great. Do we have videos? No. Do you have photos? No. Do you have text messages where you guys have talked about this? No. Did you go to therapy and discuss this issue? No. Do you have family members who have ever seen him do this? No. So what am I supposed to do? Like, what am I supposed to do with that? So is your testimony evidence? Absolutely. Okay. So you have the ability to go in and you have to get to tell your story, but it becomes a credibility issue, right? Like, of course, you're going to go in because you don't want him to have overnight visitation with your children. You're going to tell whatever you have to tell the judge in order to try to meet that goal. And the judge is very much aware of that, right? And so the judge is going to say, okay, well, you're saying he had this drinking problem, but when y'all were together a month ago and you had to drive home from your cousin's birthday party, had he been drinking? Yes. Well, who drove home? Well, he did. And you let him do that when your children were in the vehicle? Well, yes. Okay, well then obviously it wasn't that big of a concern for you, right?
Yeah, we had a case recently where a child or young kids had made some outcries to a particular parent, and there were some things that the parent had seen, and there were a few documents that kind of help paint the picture. But 90% of our testimony, I believe in this case, this parent legitimately believes something was going on with these kids, right? something was happening. It was very concerned. But in this particular scenario, 90% of the evidence came from our client, right? And it can go one of two ways with the court, right? The court can say, I believe she believes it. I just don't have enough evidence, right? Or I think maybe she's making this up to interfere with the relationship. Now I'm going to take custody.
Right.
Because you're making these allegations that are false allegations because the court does not believe that you're credible, and you could lose custody over it, right? And so it's a very risky avenue to take to go into court with not enough evidence, because if the judge views it the wrong way, it could really flip on you.
Now, I will say, in those particular cases, I would say 9.5 times out of 10, when our clients legitimately believe that there are safety issues, we advise them of the risk of having the hearing, but normally we will go ahead and go in and give it our best shot, right? Because I think, it's the love-hate relationship that I have with family law is that because these are your babies and because it is so emotionally charged, sometimes people just have to see it and hear it and know it for themselves. And if they don't try, and Lord forbid something happens with their kiddo, it will always be in the back of their mind of, if I had only had that hearing, right? If I'd had that hearing, then maybe this other thing wouldn't have happened. So, sometimes we do go in, we push that envelope, see what we can accomplish for them. And I'll say, we're talking about the things that we can't necessarily prove. A lot of times, we do have dad got into a car accident with kiddo, but now dad's saying that he wants standard visitation. He's not going to settle for anything less. Well, okay, then we'll see you in court, right? Sometimes we have dad who got smoking weed and the kiddo was a foot away from them. Okay, but dad thinks that he should have primary custody and he's not going to settle for anything less. Okay, well, now we have to go to court.
Or you have a social media video of dad smoking with the child present.
In the car with all the windows up.
Right.
We had that happen before.
Or a child that took pictures of the drugs in the center console of the car. Right? Sometimes there is pretty good evidence. Obviously, those are safety concerns, and those are cases we should be trying.
And so, here's the thing that is beyond frustrating when we're talking about settlement that I tell people all the time. You are only 50% of the equation, right? And so sometimes
you use that speech too?
I do, yeah. So sometimes you have the opposing party who is just unreasonable and not realistic, and especially when I notice a lot when parties have been victims of an abusive relationship, what ends up happening is they use the litigation as a form of abuse because they can't hit you anymore and they can't be emotionally abusive to your face. Now they start using this as a means to try you and abuse you emotionally. And so they take these unrealistic, unreasonable positions. We just had a case where we had really good evidence that this dad was abusive towards these kiddos, like video evidence of things that had happened. And he would not agree to supervised access. He refused for months and months and months. And thank the Lord, we did finally just settle that case in very favorable terms for our client.
And the kids.
And the kiddos. Yes. And so, but it was, we had to push litigation after litigation until finally he just threw his hands up and said, I know that as long as you guys are on her side, I'm never going to win. So I give up. Right.
I think that was verbatim.
Yeah, exactly. And so, but it is frustrating and it is hard, right? Because I think both Floyd and I are really good about telling our clients, here's the reasonable position to take, right? Here's what the judge is going to do. This is what you should do. Most of the time our clients listen to us and they say, okay, if y'all say that's what I need to do, I'll do it. But then the other side is ridiculous.
And sometimes it's reversed, right? Particularly when we're dealing with domestic violence victims, right? They don't want to fight. They don't want to go to court. Right. And we're telling them, no, you need a protective order in this case. We are going to have to go litigate this. Right. Obviously, they can say no, right? But we're pushing the other direction. Like, your kids are not safe unless we go get this order.
Right.
I know you don't want to get up there. I know you don't want to face them. I know you don't want to testify. I know it's emotionally hard for you, right? But this is what you have to do to protect you and to protect your kids.
Right.
It's difficult to see the victims of family violence that just want to bow down and continue to bow down to their abuse. And that's when we have to stand up and say, look, you need to stand up for yourself.
Right.
Right.
Well, and next topic we talk about is when you should fight as hidden assets. And I just remember a case where, our client had crippling anxiety. I mean, she did not want to take a break. Okay. So
She didn't want to take a break, though.
The next issue is like when you should fight, it pertains to hidden assets, right? And so we talk a little bit about people who are victims of abuse, but I've also had it where a client just had this crippling anxiety and she did not want to take a witness stand so badly that she was willing to give, I think it was like $250,000, just like give it up, like I can't do this. And I was like, you are going to do this. Like I probably, like there's no way in hell he's ever going to get that if you'll just give me 10 minutes and just stay with me. I promise you we'll get you through this. And, she had a tough time, but she got up there and she did it. And I think for sure he didn't get that. I think she ended up getting way more than what she had originally wanted. And so sometimes you have to find that gumption within yourself and to say, I'm going to go and do it. And I'm going to fight because this is the right thing to do.
And to be clear, for those of you that don't know, we cannot do family law on a contingency basis. So we do not have financial interest in her taking the stand.
Yes.
I'm just thinking, people are thinking, yeah, because you made $75,000. No.
No, we did not make any money. It was just the right thing to do, right? That was the right thing for her. It was, this guy was just not a good dude. And so, next reason you should fight, right? And we have this conversation quite a bit with clients is when we believe that there are hidden assets, or maybe not even hidden assets, but maybe you don't even know anything about the estate because you always just let your wife handle it, or you always just let your husband handle it. And so, we had this happen in a case a few months back where husband was, made all the money, wife really didn't know anything, and they were pushing us like, we're going to settle, we're going to get into mediation, we don't want to give you discovery, we don't. And for a while wife was kind of like, oh, it's fine, we're going to go. And we were like, no, pump the brakes.
Red flag.
Yeah, like there's something going on here that we don't know about. And so we have to fight, right? We have to do discovery, we have to do depositions because there's something going on. And lo and behold, we found close to $1 million that she was entitled to that we would have never known if she had chosen to not fight. Right? So, what other issues and hidden assets? I think that's probably...
it's probably all on hidden assets.
Domestic violence, we've already touched on, so we don't need to go there. False allegations.
I don't know what that is.
You don't know what false allegations are?
I know what false allegations are, but I don't know why that would be a basis to fight unless because if they're falsely accusing my client of being a danger to the child, we're fighting anyway, right?
Right. I think that's what we're talking about here in the outline. So a lot of times we're on the other end of that, right? Where hypothetically speaking, mom is claiming that our dad is a danger to the children and therefore he should not have access. And they start making all of these false allegations of, abuse and drug use, etc., because they're trying to restrict or deny or sometimes even terminate his rights to his children. And when that happens, obviously, you have to go in and you have to fight to be able to preserve your relationship with your kiddos.
And I think where I've seen this most, now as I think about it, what I've seen this most when I've started litigation because of false allegations is CPS stuff, right? When they're constantly filing CPS reports accusing my client of physical or sexual abuse of the children, and there's kids are constantly undergoing, evaluations and interviews and SANE exams and things like that. I will tell them, yeah, let's file. Let's get into court. Judges do not like that. These CPS investigations are constantly being ruled out because there's no evidence of any of this. She's just doing it to jack with you, right? And so those types of false allegations, we'll initiate litigation for those types of stuff.
Right. So when is a settlement smarter? So the first thing that we have here is minor property disputes. So I remember several years back, we had, probably close to $1 million estate. And we had settled everything. We had settled custody. We had settled property, who's keeping the house, everything was good. And the only thing that we were fighting about was Tom Hardy salt and pepper shakers. I guess they were very rare or unique, or hell if I know. And they were expensive salt and pepper shakers.
Not worth what they paid us.
But that's at the end, me and opposing counsel were like, okay, you buy the salt shaker, I'll buy the pepper shaker, and we're done. Like, we got to get out of this, because they were spending thousands and thousands of dollars over. And I mean, they were saying, well, we'll give them this for the salt and pepper shaker, and we'll trade this and we'll trade that. And it was just like, come on, guys, like y'all could buy this stuff 10 times over. A lot of times what I think happens when you get down to the salt and pepper shakers is it is
really good salt and pepper shakers.
No. It is that the parties are not emotionally and mentally ready to have this process end, right? And it becomes this like, this is the final thing that has to be resolved, and I'm not going to fight anymore. Like, no, we're going to have to keep this party going. And just don't do it, guys. Like, I promise you're going to regret it later. You will regret it later. So I always tell my clients, and I know you tell your clients this too, is, okay, if you want to have a contested final trial over the salt and pepper shakers, you're looking at $10,000, $5,000, $20,000, $2,000. I don't know, whatever it is. Let's just say it was $2,000. Are the salt and pepper shakers worth $2,000? And if the answer is no, then you settle. Then you walk away, give them the damn salt and pepper shakers, and now we move on to, buying our own and buying something bigger and better, and finally having some peace in our lives. Right?
Solid advice. Yes, that those conversations are fun to have. Like, it doesn't make business sense.
Right?
Like, why are you doing this? But sometimes they just need to fight over them. Emotional revenge battles. That's next. I don't know what that is.
We say that a lot, right? So emotional revenge battles. So you're just emotionally charged, and it is, I'm going to make the other side pay, right? I am going to hurt them. I want to destroy them. I want them to be held accountable. And I don't care how much. You have a case like that right now.
I do. I agree.
You know exactly what this is. I
have never heard it called that. I am familiar with the facts of an emotional revenge battle.
Right. And here, I feel like those are the most like sad and the most like frustrating for me when we're on the other end of that, because you have to keep fighting and you have to keep paying because they're emotional and they want revenge.
And these cases are a lot of the ones where I have to call you in and be like, I need you to talk to this client because they're not listening to me. And I do so well with emotional clients. That sometimes I have to call Christina and be like, look, I need you to talk to her. She's making a terrible decision because she's upset and she's crying, and I deal really well with women that cry. So I'm very familiar with these. It's really hard to talk them off the ledge when they're thinking emotionally and not logically. And I have to tell them, like, you hired me to be logical, right? To help you with this side of it. And please listen to me, right? Go to counseling, talk about your emotions.
Right.
Here, let's make the right decision. But sometimes it doesn't.
Well, and you said it earlier, and it's difficult to do. Like, much easier said than done. But you have to, when you're approaching these cases, you have to look at it from a business perspective, especially if you're in a divorce, and especially if there is money to be divided between you and your spouse, because ultimately that's going to help you raise your children, right? And what you don't want to do is be so emotional that you're running through the community estate. And I tell people all the time, if you want to fight, great, fight. But the only people that are winning in this context are the attorneys, right? Don't do it, right? If it's something silly, if you're just being emotional, you got to pull yourself away from that, because sometimes this is all money that people are going to get for, years and years to come, especially if you're a stay-at-home mom and, hypothetically speaking, your husband had an affair and he was the primary income earner and you're hurt and you don't understand it. So you want to make him pay. Well, in the end, you're paying because you're losing all of this money because the lawyers are fighting, right? So.
Yeah, I'm very familiar with that.
Yep.
Hundreds of thousands of dollars on this case. And it's crazy.
Right. So we talked about situations where trial costs exceed benefits. We kind of, said weigh what you're fighting for against, how much you're going to pay your attorneys. Almost in every single mediation that we have, I will say okay, this is what you're asking for. Here's how much I think it's going to cost you. You're going to come out $5,000 ahead if you go to trial. Is it worth $5,000 to you? Most of the time it's no, right? Other times it's like, hey, you're going to lose $500,000 if you take this deal now. This is a BS offer. We're going to trial, right? The math and the business, you have to think about that.
So I always tell my clients in our pre-mediation meetings, like, I prefer to never settle for something I can get in court, right? If you offer me what I can get in court, I'll take my chances and see if I can beat that in court. But as the client, they need to be thinking about the cost of litigation, not only financially, but emotionally, of ongoing litigation, because it could be another year before we get into court, right? And so that is...
You need to reframe that, because if it's what you're going to get in court, then I think you settle. If it is your worst day in court, I think is what you're trying to say.
Yes. Yeah, like if I can beat it in court, I'm going to go to court and beat it, right? But they also have to think about the expense of litigation financially and emotionally, right? And so although it may be slightly below my worst day in court, they may want to take it to prevent from having ongoing financial and emotional drainage.
Okay. And so, I had that happen a while back where, probably rightfully so, opposing counsel was offering my absolute worst day in court. My client had made some pretty grave mistakes. And, she was just like, you need to settle. And I was like, why would I settle? Right? This is my worst day in court. And so we go into the courtroom and I just start basically having fun. And we walked out on a break and she looks at me, she's like, what the hell are you doing? I was like, I'm just having a good time. Like, I have nothing to lose. You put me in the absolute best situation. And then we ended up actually winning that particular hearing, which was crazy. And so, that's when you don't settle, right? You're going to give me my worst day. Let's just have some fun. So
yeah. Enjoy it.
Yep. So emotional traps, we've talked about it. Don't fight just for the sake of winning. Nobody wins in the context of divorce. Nobody does, right? I guess the lawyers, if you're going to fight because you're being emotional, don't do it. Don't. And if you have an attorney who is pushing you to fight, you might want to look at that relationship and figure out, are they doing it because it's in my best interest, or are they doing it because they want billable hours, right? I'm a big proponent of settlement. I try to tell other attorneys, let's settle. I try to tell other attorneys, we don't need this hearing. Here's what the judge is going to do anyway. Sometimes it works, sometimes it doesn't.
Ego versus outcome. Check your ego at the door, right? This is where we're thinking logically, not emotionally. I saw a sign once that said, swallowing your pride does not cause indigestion, right? Sometimes. It's very hard to do, right? But if you get past I want to get back at them, right, and realize the more important things are taken care of, then you'll settle it.
So the other thing that you have to think about with the emotional trap is, how is this going to affect your long-term relationship with your co-parent? I have literally sat clients down and said, listen, we can have this hearing and we can air out all of y'all's grievances and sling mud. But this moment right here, you will never get past, right? And I don't know that you will ever have a good relationship with the father or the mother if you do this. Is this really a hill that you want to die on? Or is this maybe something that we can let go and do something that might be positive for you and your children?
Yeah, because you have to co-parent for the rest of that child's life, right? Not the rest 18 years, or next 18 years, or whatever it is, right? The rest of that child's life. And when you go to court and you start bashing them, because that's our job, is to make them look as bad as possible, and it's their job to make you look as bad as possible, air out all this dirty laundry in front of everybody, making accusations and bringing up private conversations you guys had as spouses or in a relationship or whatever, and hash it all out, it's almost unforgivable, and it'll be bad forever.
So, cost benefit analysis. You need to be doing that throughout the entirety of your case, right? Do I need to do discovery? How much is it going to cost me? How much is it going to benefit me, right? Do I need to have a contested temporary hearing? How much is it going to cost me? How much is it going to benefit me, right? Everything that you're doing. And I'm not just talking about money, right? I am talking about time. I'm talking about stress. I'm talking about the effect it's going to have on your co-parenting relationship, and the effect it's going to have on your mental health, on your spirituality, like all of the things. There's this constant cost benefit, right? I would say again, if it's something that's pretty damn close to what the judge is going to order, probably should take a settlement. Like that's, that's typically the way that I frame my settlement negotiations. And I'm always looking at attorney's fees, right? How much is it going to cost you? So, what else?
I think that's pretty much it.
So, final framework. Is it about safety or is it about ego, right? We got to think about those two things. Is it about long-term financial benefits? Is it about having a good co-parenting relationship? Is it about just winning? Is it just about my ego? Those are questions and conversations that you guys really need to be having with your attorney if you find yourself in a situation where you get caught up in litigation. Okay, so as we always say in these podcasts, this is not to be construed as legal advice. We are not your attorneys. We just have some experience in this realm. And so we have a whole ton of experience in this area. If you find yourself in litigation, please hire an attorney. Make sure that that attorney is local to your particular area. Listen to that attorney. And if you are in the DFW area, so Dallas, Louisville, Flower Mound in West Texas, Midland, Odessa, also here in North Richland Hills, make sure that you contact our firm if you need our assistance, and make sure that you like, follow, and subscribe on TikTok, Instagram, LinkedIn, Facebook, all of the social media platforms.